Welcome to today's deep dive. When you picture a casino, there's always that one guy at the roulette table trying to sneak his chips onto the felt right after the dealer calls no more bets.
Right, yeah, the classic late bet.
Exactly. So digitize that, speed it up by 1,000, and you essentially have a $1 billion blind spot. And that blind spot is exactly what a company called You Call the Play, or YCTP, is exploiting.
Oh, yeah. They are cornering DraftKings in what is honestly one of the most ruthless legal sieges we've seen in a long time.
It's wild. So our mission today is to really unpack this meticulously crafted legal offensive. We are exploring how a highly technical patent filing over micro-wagering architecture transforms into this multi-front corporate siege for you.
Well, to understand it, we kind of have to establish the battlefield first, right? Which is micro-betting.
Right.
We all know live betting moves fast, but the real enemy here isn't just speed, it's latency arbitrage.
Yeah.
Think about betting on the result of the next pitch in a baseball game. It takes a few seconds for an umpire's strike call to travel from the physical stadium to the data center and then finally to your phone screen.
Right. So if you're actually sitting in the stands, you could technically place a bet on an outcome that has, already happened in the real world before the Sportsbooks app even updates.
Which is called past posting.
Mm-hmm.
And DraftKings just dropped $200 million acquiring Simplebet to dominate this exact space, making them highly vulnerable.
Okay, let's unpack this. It's essentially like trying to stop someone from placing their chips on a roulette table after the ball has already dropped.
Yeah, exactly. And YCTP claims its patents, specifically the 737 and 893 patents, cover the foundational timestamp gating logic required to prevent this.
Wait, really? The mathematical logic that stops it?
Yeah, the patents basically cover the logic that mathematically freezes the timeline, closing the market before that latency gap can be exploited.
Wow. But here's where it gets really interesting to me. DraftKings is a massive digital app, right? Their cloud servers are probably sitting in an AWS data center in Virginia?
Sure. So how do you trap a national cloud-based digital app in one specific physical judicial district? Because YCTP purposefully anchored this lawsuit in the Western District of Washington.
Well, they bypassed the usual tech-friendly courts because they needed a court that could physically grasp the mechanics of betting. In Washington state, DraftKings partners with the Tulalip tribal casinos.
Okay.
And state law mandates that mobile sports wagers can only happen if you are physically on the casino property. To comply with that, DraftKings has to deploy this hyper-localized geofence.
Oh, which turns a cloud-based app into a physical footprint. That is so clever.
It is. YCTP's founder actually traveled to the casino, tested the geofence, and got printed wager tickets to prove the app is a location-dependent operation tethered directly to that physical district.
Wow. So they used DraftKings' own compliance technology against them.
Yeah, to anchor the venue.
That's crazy.
Mm-hmm.
But the pressure doesn't stop there, because YCTP is also making this incredibly aggressive demand for 16% of gross gaming revenue on these micro markets. Right. Which is just a massive number.
Yeah, and you're probably wondering why they demand a number that would completely cannibalize DraftKings' profit margins.
Well, the payout isn't even the point. Demanding 16% forces DraftKings to expose their highly guarded internal profitability data during legal discovery.
Oh, wow.
Yeah, as a public company, having to open your most sensitive financial books is just an agonizing position.
Right, but the real squeeze, the unorthodox part, is this extra legal threat involving the Apple App Store.
Yeah, this is the kill shot.
How does Apple even fit into a patent dispute?
So YCTP isn't framing this to Apple as a simple IP issue. They plan to report DraftKings for a, quote, regulated gaming integrity concern.
Wait, really?
Yeah, Apple has incredibly strict anti-money laundering and local gaming regulations in their terms of service. YCTP is arguing that if DraftKings is infringing on the timestamp patent, they technically have a failure of technical controls for lawful wagering.
Oh, I see. So what does this all mean? Are they actually trying to win a trial or just weaponizing the legal discovery process and Apple's terms of service to force a massive, rapid settlement?
It's the latter. If Apple gets spooked by the phrase gaming integrity, they could threaten DraftKings' entire iOS distribution.
It's just a brilliant strategy. It perfectly highlights how modern patent litigation utilizes regulators, monopolistic app stores, and physical geofences all at the exact same time.
It really does. It's a whole new playbook.
So it leaves you with a pretty wild thought to mull over. If the entire billion-dollar future of live prediction markets relies absolutely on patented speed and market closure algorithms, who truly controls the future of live sports entertainment?
That's the big question.
Right. Is it the massive public sports books you see advertised everywhere, or is it the unseen infrastructure engineers holding the patents?